Hello friends, welcome to our channel Steno. Subscribe our channel for more dictation on daily basis. Get ready for the dictation. The petitioner, who is an advocate practicing in this court, has filed the writ petition under Article 32 of the Constitution of India against various officers of the registry of this court and the Union of India. Prayer has been made to issue an appropriate writ order or direction in the nature of mandamus directing the respondents not to give preference to the cases filed by influential lawyers, petitioners, law firms, etc. Prayer has been made to direct the respondents to give equal treatment to the cases filed by ordinary lawyers, petitioners, and not to point out unnecessary defects, refund the excess court fee and other charges, and not to tag the cases without order or direction of the court with other cases. A prayer has also been made to direct the Secretary General of this court to take action against the erring officers for their involvement in the listing, clearing, and bench hunting. In the aforesaid circumstances, considering the ongoing pandemic caused by COVID-19, the registry of this court is working with less strength, and because of the facts described above and circumstances, we find that there was no justification for the petitioner to allege discrimination vis-a-vis to him and to favor any particular individual. The defects were there in all the three cases filed by the petitioner. The petitioner has filed this writ petition application in a hurry. When it was listed, he circulated a letter to the effect that, as per procedure, he expected that he would be called for interaction by registrar of this court to find out his fitness, whether he could argue a case in person. The petitioner ought to know that he is an advocate of this court and argues the matter in this court. As such, it was not necessary to summon him for judging his capability as to whether he could argue the case. Be that as it may, circulating such a letter was not appropriate at his stance, and why he doubted his ability to argue. There was no justification to entertain this kind of apprehension in mind. He ought to have been careful in circulating such a letter seeking a wholly unjustified adjournment. In the letter circulated by him, it was further stated that he wanted to collect the evidence and to file it, and for that purpose he prayed for 6 weeks' time. The conduct indicates that the petitioner was careless and not serious while he made the allegations. He filed writ application without due inquiries and without collecting the requisite material. Such conduct was least expected of an officer of this court. Petitioner ought to have been careful before cast off unnecessary aspersions on the registry and staff of this court. The petition as filed could not be said to be maintainable. The petitioner has impleaded the Secretary General, various registrars and officers of the registry, SCBA, and Union of India in his writ application. In contrast, writ is filed against this court itself. He ought to have impleaded the Supreme Court of India in the writ application through Secretary General. The omission indicates careless conduct on the part of the petitioner.